As the court pleases, my Lord, I'm indebted to the court for allowing us to go and prepare heads of argument, my Lord.
Okay. Thanks. Yeah.
Now, my Lord, my heads, I gave it the heading common purpose or executive statement exception, whether the state can cross-examine one accused on a confession of a co-accused. We say by way of background, my Lord, that the state is busy cross-examining Mr. Sibiya, and in the process of doing so, it has signaled its intention to cross-examine Mr. Sibiya on the statements or statement specifically my colleague referred to Exhibit JJ, which is a statement allegedly made by Mr. Ntanzi. So it signaled its intention to cross-examine Mr. Sibiya on that. And the essence of the state's argument, as I understood it yesterday, although today now they've added the second part, was that this was an executive statement made in furtherance of a common purpose. Now I hear today they are adding the second option that if it's not an executive statement, then it should be admissible against the co-accused in terms of the hearsay Evidence Act 45 of 1988, my Lord.
Yeah.
Yes. Now, I'll come to this, my Lord, but as a preliminary, we say that executive statements are those statements that are made by one participant to a conspiracy in the furtherance of a common purpose, and the rider is this, my Lord. While that conspiracy or enterprise or common purpose is ongoing, and the executive statement is made in the execution of that conspiracy. And we say, my Lord, and we must not be understood otherwise to say, those executive statements, if indeed they are executive statements, they are admissible against the co-accused, my Lord. Now, I'm setting forth the statutory framework in paragraph 2 of our heads, and we say, my Lord, that the admissibility of confessions and admissions in the South African criminal procedure is governed by sections 217, 218, 219, 219 capital A of the Criminal Procedure Act of 1977. In brief, my Lord, Section 217 deals with the admissibility of confessions by the accused, which simply says a confession statement by the accused is admissible against the maker, that person. Section 218 deals with the admissibility of facts discovered by means of an inadmissible confession or statement. Section 219, and which is specific in this matter or in this argument, deals with the confession not admissible against another. And it explicitly states that no confession made by any person shall be admissible as evidence against another person. And Section 219, my Lord, deals with the admissibility of admissions by the accused. And then applying the legislative framework, we submit the following, my Lord, that with respect to Mr. Sibiya, accused number 1, the state has tendered his alleged statement as a confession in terms of Section 217 of the Criminal Procedure Act. The Honorable Court has ruled that this statement should be admissible as evidence in the trial within a trial. Furthermore, with respect to Mr. Sibiya, the state also tendered an alleged pointing out and an admission statement which, my lord, may either fall under section 219A or 218. Then with respect to Mr. Ntanzi, accused number 2, the state tendered 2 alleged statements made by him as confessions, and these 2, my lord, were ruled admissible evidence against, as evidence in this matter. Paragraph 3, we just set a brief enunciation of the constitutional framework, and we refer to section 35(3) of the Constitution, which guarantees every accused person the right to a fair trial, which includes the right to remain silent and not to be compelled to give self-incriminatory evidence. Paragraph 4 of our heads, my lord, we set out in brief the relevant case law governing the issues that we are debating today. The first case that I refer the Honorable Court to is the case of S versus Ndlovu and others. The citation is 2000 in paragraph 2, SACR 325, and it's a decision of the Supreme Court of Appeal. We say, my lord, in our heads that Ndlovu temporarily widened the admissibility by allowing one accused extracurricular statements to be applicable to other accused in terms of the Hearsay Evidence Act. We say, my lord, that the court in that matter invoked the provisions of section 31C of the Hearsay Evidence Act 45 of 1988 and allowed the extracurricular statement of one accused to be used against the co-accused. And then there were subsequent cases, my lord, that followed Ndlovu as well in the Supreme Court, and we name them. They are S versus Ralukukwa, which is a 2008.
Sorry, is that Ravuku?
Ralukukwa.
Okay, fine.
It's 2008 in brackets 2.
Yeah.
SACR 394. It's a Supreme Court of Appeal decision. And there's a matter of Balkwell, which is BALKWEELL. And another, this is the States, is a 2007, 3 All South Africa reports, 465, a decision of the SCA as well. And there's also the case that followed Ndlovu, which is Mamusha versus S, which is a 2007, volume 4, All South African reports. Paragraph 4.2, the Balkwell case that we mentioned above, Supra, in the judgment of Justice Ponen, in an obiter dictum, this was not a ratio decidendi, but it was an obiter dictum. He questioned the reasoning and the validity of the Ndlovu SCA judgment and stated at paragraph 34 as follows. Ndlovu Supra makes an attempt to reconcile the incongruity, the bar created by section 219 of the Criminal Procedure Act of 1977 and the application of section 3 of the Evidence Act. Moreover, in dealing with the constituent parts of section 3, Ndlovu offers no guidance as to how the receipt of the extracurricular admissions, which it allows under this section, should be approached at common law for the exclusion of what role, if any, the common law safeguard should play. And I close quote. Then paragraph 4.3, my lord, we mentioned that the case of Litako and others, which is a 2014 in brackets 2 South African Criminal Reports 431 SCA overturned Ndlovu, the Ndlovu case in the Supreme Court in 2014. And we submit, my Lord, from our reading of Litago that there are three ratios that we can deduce from Litago case. The first one, and that is stated in Litago itself, my Lord, at paragraph 445, paragraph H to paragraph I. And it says that the Ndlovu judgment was inconsistent with the common law. And the court stated as follows, and I quote paragraph 445, H to I, that the common law rule was not only an aversion to the admissibility of hearsay evidence, but it was developed because of the inherent dangers of permitting the use of extracurricular statements by one accused against another. It recognized potential conflicts between the interests of the accused persons. Furthermore, because a co-accused cannot be compelled to testify, the common law appreciates that fair trial rights, including the right to fully challenge the state case, may be hampered. That is the first ratio. The second ratio, Decidendi, my Lord, that we deduct from Litago is this. It says that in Ndlovu, the provisions of Section 3.2 of the Hearsay Act were glossed over. And this we find, my Lord, at page 445, paragraph F to G. And it states, in Ndlovu, the High Court, the provisions of Section 3 in brackets 2 of the Act, and by the Act they mean the Hearsay Act, were glossed over. That subsection provides as follows, that section 3.2 in brackets, 3 in brackets 2 of the hearsay evidence provides as follows. The provisions of subsection 1 shall not render admissible any evidence which is inadmissible on any ground other than that such evidence is hearsay evidence. And the final ratio that we deduce from Litago is the following: that the wording of section 219 of the CPA, 219 capital A, of the CPA provides the admission of the evidence as stated at 446 H2I as follows. Evidence of any admission made extrajudicially by any person in relation to the commission of an offense shall be admissible against him. That is what we refer to when we were espousing the legislative framework. Now, I address the issue at point, my Lord, which pertains to the executive statement. And we say in paragraph 5.1 of our heads, my Lord, the executive statement exception has been succinctly articulated by the Constitutional Court in S versus Mutlongo, S versus Nkosi, 2015, what's this in bracket? I'll come to that, my Lord. BCLR 8687 Constitutional Court as follows, and I quote, at common law, there is an exception to the exclusion of extracurricular statements of the co-accused if the statement constitutes an executive statement by an accused. It may be admissible against co-accused if it was made in furtherance of a common purpose or conspiracy. There must be other evidence, that is evidence aluende, to establish the existence of a common purpose before the statement can be taken into account. The state would have to pronounce on whether the common law exception survives a finding of constitutional invalidity of the admissibility of extracurricular statements of an accused against a co-accused. Now, my lord, at paragraph 5.2, we say, to give context of our admissions on this issue, we submit as follows, that it is essential to distinguish between an executive statement and a narrative statement. What constitutes an executive statement which is admissible against the co-accused, and what constitutes a narrative statement that is not admissible against the co-accused, but is only admissible against the maker. We say, my lord, executive statements are those statements made in furtherance of a common purpose, as stated in S versus Bondi or Bondi, B-O-N-D-I, 1962 in brackets 4, SA 671, a decision of the appellate division, as it was then known, at 678 D to F. That means to say, my lord, to qualify as an executive statement, the statement must be used, must form part of the data in the commission of the crime, which is what is called, it must be part of the res gestae, the facts, the commission of the offense, my lord. And we give an example there, but it is not, I must put the disclaimer, this is not my example. This example is found in Hoffman and Zeffert, my lord. And it says, for example, if A, B, and C are engaged in a common purpose and A makes a statement in furtherance of a common purpose, it will be admissible against B and C. And that was validated in the matter of R versus Mayet, 1957, 1 SA 492, and also in the matter of S versus French Baytech, 3 SA 438 at 432 and 433. And we said that this also extends to verbal declarations made during the commission of an offense where the perpetrators act in cahoots with each other. For example, if we are committing an offense and I see somebody come here and say, hide a knife, it constitutes an executive statement, and that will be admissible against my co-accused at the time who's present with me. And the further example at 5.3, also from Hoffman and Zeffert, my lord, it says, for an example, if A and B burst into a bank, as agreed by both of them, and A exclaims, and I quote, "This is a robbery. We will shoot at anyone who resists our demands and disobeys us." Then that incriminating statement, my lord, we say, although it is actually uttered by A, must be attributed to B as well, as it was part of the mandate between them, and it was also in furtherance of a common purpose to rob the bank. And we say, indeed, that statement will then constitute an executive statement because it will be used for the furtherance of a common purpose. And we give in brackets, my lord, examples of what may constitute executive statements. For example, declarations relating to coordination, to warning, to encouragement or concealment, as I've referred in that example before. And we say, we admit, my lord, if they are executive statements, then they'll be admissible against co-conspirators, my lord. Now we compare these executive statements with what we term narrative statements, my lord. And we say narrative statements, on the other hand, are statements which are not made in furtherance of a common purpose, but rather as an account or an admission of past events, in which case they are not admissible against anyone else but the maker of that statement. And for that proposition, the case of Banda approves. It's S versus Banda and others, and 1993 SA 456B at 503 and 504. We say, my lord, narrative statements are not admissible against co-accused because admissions made in general are not vicariously admissible, but may be admissible against the person making them. Therefore, we argue, my lord, any actions or statements made to carry out a common purpose can be relevant if they are accepted. They are considered relevant executive statements, meaning they are in furtherance of common purpose. However, such statements are not admissible, merely description of confessions about things that have already happened in the past and not in furtherance of a common purpose. And importantly, my lord, and this will be found also in the TOI, that importantly, before an executive statement can be admitted as evidence, the existence of a conspiracy and the accused involvement in it must be proven by evidence aluende, independent evidence. At paragraph 6, my lord, we say, importantly, a statement made after arrest does not fall within the exception because the common purpose no longer exists. And for this, my lord, we quote the matter of S versus Mangena and Anada, which is a 2012 matter, 2 SACR 170 GSJ at paragraph 54. The court held that the admission of such evidence is based on a rational and logical inference, which is effective if the statement was made in furtherance of a common purpose. The court found that the timing, that limiting the rule in this way prevents the admission of an extracurricular statement made by one co-conspirator against another after arrest. The court noted that the principle appears generally in common law jurisdictions, as shown by the decisions of the U.S. Supreme Court. And in the court's view, the U.S. Supreme Court confirmed the exclusion of a statement made by one co-conspirator against another once the objectives of a common purpose are no longer being pursued or capable of being pursued. I want to refer the court to this American court that they cite. It's the matter of Krulevich versus United States, and I'll spell it. It's KRULEWITC versus United States. It's a 1949 USSC 33, 336 USS 40, 1949, and it was cited with approval in Wong, Wong as in Chinese, W-O-N-G, Wong Sun, that is, Sun is S-I-S-U-N versus United States. It's a 1963 USSC 15, 371 US 41 at 490, 1963. And also they quote from a text by Wigmore, volume 4 at 1079. And I wish to quote what they said in that case, my lord, if I can find it. In my head. Sorry. If the court can indulge with me, my lord, I want to get the correct citation, I mean the quotation from this American case. Oh, no, I know where it's at. Where's my quotation? I'll come back to that, my lord, before.
You want to quote this American case of 1949?
Yes.
You're giving us the citation.
Yes,
But then they quote this case in Wong.
In Wong, yes, my lord.
You know the case of Wong, 1962. Kentridge
Yes.
used this case in State versus Zuma.
Okay.
You remember that case? Where they say the past and the future.
Yes.
Kentridge was saying after this constitution, he quotes this case, Wong. Yes. East versus Zuma. Anyway, I'm with you there.
Yes, because it says in essence that if an accused person is arrested and he gives a statement to the police and he was involved in a conspiracy with another accused, once he's arrested, what he tells the police does not become an executive statement,
Yeah, fine.
but it's a narrative statement. That is the essence of Wong and Krulevich, my lord.
All right.
Yes. Okay, and in paragraph 5.7 of our Health, my lord, we say that to ensure clarity, it is important to stress that the common law exception continues as part of our legal system. And in S versus Mhlongo and Nkosi, as quoted above, the Constitutional Court was asked to decide whether the common law rule permitting the admission of statements made by an accused outside of court in furtherance of a common purpose would violate the Constitution if used against a co-accused, but the Constitutional Court found on the facts that that matter was not ripe because the issues were not raised on the facts of that case. In paragraph 6 of our arguments, my lord, then we deal with conspiracy. And we say, in the case of Litako, at 450B to C, the court held that, furthermore, other than when one is dealing with the vicarious admissions or statements made in furtherance of a government purpose, neither of which are applicable in the present case, it is difficult to see how one accused extracurricular statement can bind another. paragraph 6.2, my lord, we say, before the commencement of the Hearsay Act of 1988, an accused extrajudicial statement were admissible as an exception to the hearsay rule against a co-accused to prove the conspiracy or common purpose. And we say the exception fell under the vicarious admissions or the executive statements category. Now we come to the quotations that I said Dutoy mentioned in my previous address, that Dutoy at page 24 to page 50 submits as follows. For the following reasons, the common law exception have been abolished. A, Section 216 of the Criminal Procedure Act, which ensured their survival by applying the English common law, has been repealed by Section 9 of the Law of Evidence Amendment Act. Paragraph B, the specific treatment of hearsay in Section 3 makes it clear that hearsay cannot be regarded as a case not expressly provided for the purposes of the residuary provision. Section 225 of the Criminal Procedure has, in any event, expressly repealed, has been repealed by Section 9 of the new Act. And C, the Supreme Court of Appeal held that it was unnecessary for it to determine whether at the trial court, as the trial court has held, the hearsay evidence in question could be received under the common law exception, in this case as an executive statement in furtherance of a common purpose, since, and we quote, the inception is not regulated by Section 3 of the Evidence Act of 1988. And at page 24 to 74, Dutoy deals with co-conspirators, which he says these are special cases. He says, Dutoy, the learned author, that our law has adopted the English rule that a statement made by A is admissible against B if A and B were associated in the commission of a crime, and the statement was made in furtherance of their common purpose. And he also cites with approval Mayet and French Beitach on that matter. Sorry, my lord.
French Beitach. Do you know French Beitach?
Sorry, my lord.
Have you heard of him?
French Beitach? I haven't, my lord.
You've heard of Trevor Huddleston?
The Reverend? Yes.
Very please. Trevor Huddleston is the Anglican bishop in South Africa. And he was a very active, liberal prince and priest. They arrested him for committing what the old regime used to call terrorism act. Collected money and gave it to Nkonto Wesizwe to use to buy bombs and blah, 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 blah.
Okay.
French Peter.
So he was charged
Surprised,
under
Mr. Baloyi.
No, listening with keen interest.
Oh, I see, okay.
So was he charged under the suppression act?
Yeah, he was charged, the first priest to be charged under the suppression of communism.
Yes.
Right.
Now, as we are continuing with the conspiracy, I'm leaving what the learned author Dutoy says. And these are not contained, my lord, in the heads that I've submitted.
I see.
So I'll submit from the bar, my lord.
Okay, fine.
We say, my lord, in a case of more than one accused acting with a common purpose, each is a conspirator liable under the criminal law for the acts of every other conspirator done in pursuance of the conspiracy. We've already quoted, referred to Mayet, the 1957 case.
You're right.
And we say that the reception of such evidence is, I've already referred to this one, and I've already referred to the American case. And we say, my lord, that a statement made by an accused which falls short of a confession but amounts to an admission or other statement by the accused concerning his co-conspirators is admissible against the latter, provided that it was made in furtherance of a common purpose. Now, the issue that I want to touch on, that's why I refer to this document, my lord, it's what Advocate Baloyi now says that if the executive statement exception is not applicable, the alternative is that the Hearsay Evidence Act must apply, so that Exhibit JJ and the other exhibit, which are statements of allegedly of Mr. Ntanzi, must apply to the co-accused. And we say, my lord, the question, therefore, is whether the Law of Evidence Amendment Act allowed the introduction of such statement and whether it is constitutionally sound. If so, a further question arises regarding whether the admissibility of such statement is to be determined. Firstly, we say, my lord, the Law of Evidence Act, the Hearsay Act, did not in its terms purport to change the substantive rules of relevance. And we say, my lord, that the Ndlovu case that we cited, which was disproved by Litago, concerned itself exclusively with the application of the Hearsay Evidence Act and found that there were sufficient extraneous factors or evidence to ensure reliability of the extracurricular statement. The court in Ndlovu was not asked to consider whether the Law of Evidence Act expressly or by necessary implication extended the rule of reliability, which excluded any admission made by one conspirator against the other beyond the case where the statement was made in furtherance of a common purpose. Now we deal with what Mr. Baloyi seeks to do, that is to be allowed to cross-examine Mr. Sibiya on the evidence on the alleged statements made by Mr. Ntanzi. My lord, I must say that I was taken by surprise yesterday when Mr. Baloyi stood up and said he wanted to...
Who's that?
When my learned colleague, Mr. Baloyi,
Okay.
said he wanted to refer a statement to Mr. Sibiya, which is a statement allegedly made by Mr. Ntanzi. And he wanted to cross-examine him on that because, my lord, we've had a trial within a trial in this matter. And at the trial within a trial, in respect of Mr. Sibiya in particular, when that statement was introduced, the state indicated that we are introducing this statement so that it is binding against the maker. At no stage were the other co-accused precognized to say, should the court admit this statement as evidence, then the rest of you, this statement is going to be applicable to you. Then it will give the other co-accused the chance either to challenge or to acquiesce with the statements made by Mr. Ntanzi. Now, to come up in cross-examination and to say, now that the statements are admissible, I'm going to refer you to this statement to bind you and to bind the other co-accused, because this is an executive statement. And by the way, my lord, I submit without contradiction as well, that this is not an executive statement, and I'll show why I say that this is not an executive, those are not executive statements. And I'm also not going to give them a classification to say what they are, because the court has not indicated yet whether these are confessions or admissions. So I'm not going to be brave to say this is a confession, this is an admission. Now, to use the civil term, my lord, we say, at the time when the state says, I'm going to introduce, for example, JJ to bind you, Mr. Ntanzi, the term in civil law to say there was no lease between lease, not rental agreement, LIS, to say, Mr. Ntanzi, once your statement is admitted, I'm going to use it against Mr. Sibia. I'm going to use it against Mr. Mngube, Mr. Mapisa, Mr. Ntuli, so that their lawyers could take the necessary legal routes to protect their clients' rights regarding those statements, my lord. And with VEV, my lord, Kappa versus S is not applicable here, because it puts a certain obstacle to the state, to the admission of this hearsay evidence. Kappa says, before the close of the state's case, the state must make an application to court, which application will be debated by the state and ourselves, and the court will make a ruling to say, I want to make an application that this hearsay evidence, and expounds that hearsay evidence clearly to be admitted against the accused before court. That was never done. The bus has already passed. Now, the submissions that we are making, my lord, to say that this application by the state must fail are the following, and I'm reading now from paragraph 7 of our heads of argument. We state, my lord, that from the principle enunciated in our arguments today, it is vividly clear that Exhibit JJ and whatever extracurricular statement that the state wants to cross-examine Mr. Sibia on were made long after the offenses were committed. And we state, my lord, at the time the statements were made or allegedly made, the objectives of the alleged conspiracy as submitted by the state were no longer capable of being pursued. We submit, my lord, that such a statement or such statements are narrative statements, because they are narrating past events after arrest. Because once we apply the Krulovich Wung Song, which say, and also Nkosi Mhlongo, which say, after arrest, any statement made is not an executive statement, but a narrative statement. And we say in this case, my lord, JJ and HHFF, whatever they want to introduce, my lord, and cross-examine on cannot be allowed, because these are narrative statements which serve, if they indeed were made by Mr. Ntanzi and Mr. Sibia, to incriminate the makers themselves, but not their co-accused. And I want to state, my lord, and I'll just briefly, as an anecdote, stop here. I want to be like Mr. Mnisi, to say, if I say the statement made by Mr. Ntanzi, I'm in no way saying he made it. I'm saying in the context of this argument, because tomorrow I know it will be quoted to say, during argument on the 13th of 2000, Mr. Ramosepele stood here and said, you made a statement. So I don't want, on the right-hand side, when arguments come later, Mr. Ntanzi is held to the contents or the argument that I'm making specifically for this interlocutory application. And then I'm called never ever, everything never ever. And then paragraph 7.2, my lord, of our heads, we say we submit that to cross-examine Mr. Sibia on the statements that they want to introduce does not fall within the exception because the co-accused at the time of the trial within a trial, or even in the versions presented by their respective counsels, have never by word or conduct accepted the truthfulness of what's contained in the statements that the state want to adduce and to cross-examine Mr. Sibia or any other witness on. Paragraph 7.3, we submit, my lord, that the conspiracy on or common purpose ends upon the completion of a crime, arrest, abandonment of the conspiracy, or separation of the co-conspirators. And any statement that is made thereafter, my lord, is detached. (7.4), as I alluded earlier to say, executive statements are made in furtherance of a crime. For example, when somebody says we are together, say hide the weapon. We say, my lord, that confessions are made to explain or to justify past acts. They do not advance the common purpose. And we say further, my lord, that the common purpose exception should narrowly be applied, and specifically for matters that are done or said in the ongoing conspiracy, common purpose. They cannot be admitted against the co-accused under any guise, be it under Section 219, under the Hearsay Act, or under common law. Finally, my lord, we say that executive statements are not even made to police officers. Executive statements are made to co-conspirators. And for that, for those reasons, my lord, I say the application by the state stands to fail, as the court pleases.
Okay. Sorry, what's the time now?
11:25, my lord.
Yeah, okay, let's adjourn it. As Mr. Umalo is getting ready.